Executive Director of the Coordinating Centers of Excellence at the Department of Psychiatry at Northeast Ohio Medical University. And I'm going to go through a few things before turning this over to Christina. Bear with me just a second. I see a few people popping on and coming up in the speaker slot. So let me get those folks in. Looks like our numbers are still growing. They're bopping around actually as people are trying to get in different spots. Okay. Hang on just a second. Right, well, I'm going to keep my introduction even more brief than planned, so Christina has plenty of time. I want to thank you for joining today's video conference, and we apologize for the snags in getting you all in here with the current situation such that it is. There's just a lot of vying for bandwidth, and we are also recording this session. So Haley Farber from the Criminal Justice CCOE will send out to everybody access to the recorded session afterward, just in case there's any pieces of it that you want to listen to again or that you couldn't hear the first time. Today's session is about sharing confidential mental health and addiction information in Ohio, specific to mental health and addiction providers and courts and jails at initial detention and initial hearing. Before I introduce Christina Shaynak-Diaz, who's our presenter today, I want to provide some logistical information and just brief background about the Criminal Justice Coordinating Center of Excellence, who's sponsoring this current project. So this conference is scheduled for up to 2 hours, and it's a good thing we did that since we're getting off to this slow start. We've got over 200 participants registered today, which is part of the bog down, but a wonderful turnout on what I think is a very important topic. And we've got folks representing a number of disciplines, including law enforcement, mental health, courts, veteran services, probation, corrections, legal counsel, health care, managed care, and a variety of other disciplines. And because of the size of the group, all participants in the conference, except for Christina and myself at the moment, but I'll mute myself too, and the host site have been muted, and please do not unmute yourself. If you do, your name appears in the center of the screen, so I can see somebody else's name besides Christina showing up. So please look at the bottom left corner of your screen. You'll see a little microphone, and press that until you see a red bar over it so that you are muted. And then the start video icon next to that should also be clicked so that you're not showing up on the camera. We have asked for questions to be submitted prior to this seminar, and we've got a few in the queue already. We will make time at the end of the presentation for additional questions and answers. And you're welcome and encouraged to do that at any point in time that they come to you. You can use the chat box for that, and Haley and I will try to make sure we snag each and every one of those. I already mentioned that we're recording the session. We'll release that information at a future date. So moving on, brief background, the Criminal Justice Coordinating Center of Excellence is hosting today's video conference in conjunction with and support from the Ohio Department of Mental Health and Addiction Services through SAMHSA Block Grant funds. And the creation of the manual that preceded this was also supported through those same dollars. The Criminal Justice CCOE was created in 2001 to encourage communities throughout Ohio to forge collaborative relationships between the mental health and criminal justice systems so that individuals with mental disorders receive the care they need. The center serves as the Crisis Intervention Team Technical Assistance Center for Ohio and offers sequential intercept cross-systems mapping for both adult and juvenile mental health and opioid responses. And we provide technical assistance across the intercepts for these interface areas as well. For many years, we've been fielding questions and concerns regarding difficulties exchanging meaningful and helpful but lawful releases of protected health information between justice and mental health systems, and misunderstandings about HIPAA and other applicable laws. And a couple of years ago, we asked attorney Christina Shaynak-Diaz to present to the body of attendees at an Ohio Advanced CIT training conference on the issue of disclosure of protected health information, at that time specific between law enforcement and mental health. And that presentation really kicked off a variety of discussions about the need for documents that crosswalk the applicable state and federal laws and regulations that affect meaningful information exchange between mental health and addiction providers and various criminal justice entities. So Christina authored the first manual, which focused on the exchange of law enforcement and behavioral health information between those two systems. We held a webinar that was highly attended and well regarded, and this is the second in what we hope is going to be a series of at least 5 such manuals walking through each of the intercept points. And so we're grateful to be working with Christina on this project. And I'd like to, and I just lost her bio. I want to give you a quick bio of Christina so you know where she's coming from and her expertise, and then hand it off to her to go ahead and get started. So Christina is a licensed attorney who earned her Juris Doctor and Master of Social Work and Bachelor of Arts degrees from the Ohio State University. Christina is currently a sole practitioner specializing in behavioral health law, public agency compliance issues, and state and federal confidentiality laws. In addition to providing legal counsel to various public and private entities on these topics, she also provides training related to these topics around the state. She's currently drafting this series of manuals for the Criminal Justice Coordinating Center of Excellence that I just mentioned to you. And she recently participated on the Attorney General's Task Force on Criminal Justice and Mental Illnesses Subcommittee on Policy and Legislation, and represented the subcommittee at interested party meetings, including those related to Ohio's standard authorization form. Prior to starting her own practice, Christina was the Chief of Legal Affairs and Policy Development for the Ohio Association of County Behavioral Health Authorities for 5 years. In that role, she advised the association on legal matters, addressed legal issues from the association's membership, developed informational materials, and gave presentations on confidentiality laws, sunshine laws, ethics laws, and other issues related to compliance. She was the OACABA representative for various state level initiatives and work groups related to confidentiality, and also worked closely with the Ohio Department of Mental Health and Alcohol and Drug Addiction Services to assist Ohio's public behavioral health system in confidentiality law compliance. Prior to that, she gained experience in a variety of ways in the criminal justice system as a social work intern in the Residential Treatment Center at the Orient Corrections Reception Center, and a law intern in the Legal Services Division of the Ohio Department of Rehabilitation and Corrections Legal Services, and a variety of other things. And so I don't want to take up any more time. I want to hand this off to Christina to get us rolling on the content for today. Christina, take it away.
Thank you, Ruth, for the introduction. Hello, everyone, and thank you for joining this afternoon, and thank you for your patience in dealing with the connection issues we had. I am going to attempt to share my screen here and get the presentation going, so bear with me while I... Can everyone see that on their screen, hopefully?
Yes.
All right, thanks, Ruth. All right, so as Ruth had mentioned, there was a lot of interest in this manual, just like there was a lot of interest in the first manual in the series. And frankly, it's really exciting. The list of people on this call today is really impressive in terms of the multidisciplinary nature and also geographic locations all around Ohio. It wasn't lost on me when I looked through the list of participants who we have on there in terms of law enforcement, healthcare professionals, hospital workers, a lot of people that are currently on the front lines of the COVID-19 emergency. So thank you to all of you for all that you're doing out there, and I hope this provides a nice respite from that very serious and work that we are all very thankful for. So without further delay, let's go ahead and get into an overview of the manual first off, and then we're going to get into the laws themselves. So the purpose of the manual, Ruth had went over a bit of that. We want to get a common understanding amongst all the professionals involved in the sharing of this information, facilitate information sharing, improve collaboration, hopefully simplify the application of the confidentiality laws. That's the second part of this presentation, where I want to essentially build that common understanding, the groundwork for these confidentiality laws and how they apply, so that when you're out there doing what you do on a regular basis, you can use that groundwork to draw upon to answer questions you might have about disclosing or receiving confidential information. In the manuals, we try to include tools and resources that can assist you. As we'll see here in a bit, a lot of the manual is addressing common scenarios, hypotheticals, FAQs, most all of which came from those of you out involved in the sharing of this information every day. And, you know, bottom line is to ultimately improve the assistance, the provision of services, the meeting of the needs of persons with mental illness and substance use disorders. Hopefully everybody has had a chance to at least flip through the manual at this point, and hopefully it's arranged in a way that makes it rather user-friendly. So if you're wondering about HIPAA, you can flip to HIPAA. If you're looking at 42 CFR Part 2, you can go to that. If you have a specific question you're trying to determine answer to, you can go to the FAQs in the back. So the manual itself, just quickly, it starts off with a summary of the confidentiality laws, kind of a high-level overview of HIPAA in Part 2, how they apply, to who they apply. It then goes on to addressing the exchange of information with jails during initial detention, part of the second intercept, and the exchange of information with courts during the initial hearing. And those sections talk specifically about the disclosures that are permitted under the confidentiality laws to courts and to jails by healthcare providers. And then those sections also give some additional considerations to keep in mind when you're looking at that exchange of information with jails, with courts. What I hope is a very helpful part of the manual, and what I really try to pour a lot into for each manual, is the common scenarios and FAQs. A lot of those come from the trainings I give on these topics all around the state, questions that are raised by those attending the training, questions when we do each of these manuals in the series. We have a small group that gets together from the stakeholders involved in the subject matter of that manual. So for the first manual, we had law enforcement and behavioral health providers working with me, helping me understand the day-to-day operations and considerations and questions that come up. Likewise, on this manual, we had a small group of people from jails and courts and behavioral health providers to help me better understand what I needed to address in this manual. And then once it's drafted, we have it reviewed by another group of individuals who give their suggestions, ask additional questions, what have you. So these common scenarios and FAQs aren't just something I thought would be helpful to put in here, but seem to be what are the most common questions out in the field. And then the end of each manual has an appendix section with resources. For this manual, there's the text of the applicable laws that we're going to be talking about, as well as forms that you can utilize. Some specific things I want to point out about the manual, other than the different sections. Most of the sections have an important considerations section, and that's where I give additional explanation or hit on major points to understand and consider when looking at the sharing of information addressed in that section. I always like to address in the manual and in presentations what is not protected. There's still a lot of misconceptions about who is required to comply with these laws and what information is protected. So I always like to show the flip side of that to enhance understanding. I think it's just as important to note in determining how the laws apply. There's a recommendations section, and that's where I put in some additional overarching approaches to facilitate information sharing, additional ways information can be shared. And then for this particular manual, in the appendix, there is a section for releases of information or authorization forms, however you want to refer to them. It provides both a multi-party release of information form that I drafted. It also includes the standard authorization form that Ohio just put into effect, I think a little over a year ago now, maybe a little longer than that at this point. But Ohio's form, the instructions for using that form, it's all in the appendix along with my multi-party authorization form. So hopefully those will be helpful for you, and I will address the use of the forms a bit as we move forward. Before we move on to the presentation itself, as Ruth said, we are planning on doing a manual for each intercept in the sequential intercept mapping. So the next manual will be jails and courts, whereas this one is more the, it starts with jails and courts, but specific to initial detention and court hearings. The next manual will really get into the substance of information sharing with those in jails and those involved with the court system and further into their proceedings with the court system. So that's the manual in a nutshell. Again, hopefully you have all had a chance to go through that. The rest of the presentation today will be building that framework that I had mentioned, giving a presentation on some of the major points of the confidentiality laws and laying the groundwork for better understanding of those laws. It's a short period of time that we have, so this is kind of going to be the higher level overarching requirements when we look at the sharing of information between behavioral health providers, courts, and jails in regard to persons with behavioral health needs. So first we'll look at the confidentiality laws themselves, who they apply to and the information they protect. I'm going to talk specifically about the disclosures that each of the federal laws permit as it pertains to the criminal justice system. The sharing of information between systems gets a little more specific to sharing between jails, courts, and behavioral health providers. And I have some specific recommendations and considerations for sharing between systems. And then we'll have some Q&A at the end. I'm not going to walk through all of the FAQs in the manual itself. You have that in front of you, and I hope it's in a rather straightforward format. For the Q&A section, we'll look at the questions that were submitted prior to the presentation. There were just a few of them. And then depending on how much time we have left at that point, we will walk through the questions that are being submitted during the course of the presentation. Ruth and Haley will be monitoring those, and we'll get to as many of them as we can, and hopefully the presentation itself will answer a lot of your questions. That's my intent, at least. So moving on to the overarching look at the confidentiality laws, what the manuals address and what is pertinent to the information of those involved in the behavioral health system are the two federal laws, HIPAA and the Confidentiality of Substance Use Disorder Patient Records. That one is a bit lesser known than HIPAA, but it has been around a lot longer. I think it went into effect in the early 70s. I'm going to talk about who that applies to and how it applies, but it's commonly referred to by 42 CFR Part 2 or just Part 2, so that's how I'm going to refer to it throughout the presentation. And then a bit of state law. The behavioral health confidentiality laws in state law have pretty much been brought into line with HIPAA and 42 CFR Part 2 at this point. So the only state law specific pieces covered in the manual are the jail related statute and rules. They have their own set of confidentiality rules for those working in the jails, and those are included in the manual. So HIPAA in Part 2 will be our main focus. In regards to HIPAA, it really applies to three types of entities, but the third is actually such an obscure category that HHS is talking about removing it from the regs. So typically when we talk about a HIPAA covered entity, we are talking about health plans, which could be private or public. So Anthem, United Healthcare, the big health plans. It could also be our public benefit payers. So the ADAM boards, OMOS would be considered a HIPAA covered health plan under HIPAA. And I want to point out, and it's going to be important as we move forward in this presentation, that not all healthcare providers are a HIPAA covered entity just by being a healthcare provider. HIPAA states that it has to be, or in order for somebody to be required to comply with HIPAA, they have to be a healthcare provider that conducts certain transactions in electronic format. So a purely paper-based provider, not doing electronic claim submission and authorizations and things of that nature, would not be required to comply with HIPAA. A lot of them voluntarily do now, or other areas of law may require them to comply. But when it comes to HIPAA itself, not all healthcare providers are HIPAA covered entities. For those that do fit that criteria, healthcare provider includes physical healthcare, mental health care, addiction services, providers, pharmacies, chiropractors, all of those providers that conduct electronic transactions in regard to the services that they provide. It's also important to note who is not HIPAA covered. I get these questions a lot, frankly. I just got one the other day. It's important to note that HIPAA applies to those healthcare providers that conduct certain transactions in health plans. Law enforcement's not HIPAA covered. Probation and parole officers are not. Court personnel's not. Schools not. Family members and friends are not HIPAA covered. Employers are not HIPAA covered. They may receive from their group coverage plans certain protected information from those health plans, but in and of themselves, they are not HIPAA covered. Jails are sometimes HIPAA covered, and we're going to talk about that when we get to the jail section. So in a nutshell, if you are not a person or an organization that provides healthcare services, pays for healthcare services, or provides services to those that do, you are not a HIPAA covered entity. You might be receiving HIPAA covered information from a HIPAA covered entity, but you or your organization are not HIPAA covered unless you fit into that healthcare provider or health plan category. In terms of the information that HIPAA protects, it's information that relates to a person's physical or mental health condition. The information is created, received, transmitted by one of those HIPAA-covered entities in their provision of healthcare or payment for healthcare services, and it identifies the person or can be used to identify the person. So it's pretty much any person-specific information obtained about a person in the course of providing those covered entity services to that person, provision of care or payment for that care. That is what we mean by protected health information. And that is important to note too, when you're looking at what confidentiality laws apply. Was the information created or received by a covered entity for the provision of healthcare services or payment for those services to begin with, as your first question in terms of how HIPAA applies? And we're going to walk through that a bit more as we get into the sharing of information. So HIPAA is really broad in terms of the information that it protects. It's pretty much anything that the covered entity collects in the provision of those services or payment for those services. The confidentiality of substance use disorder patient records, federal law, or as I said, 42 CFR Part 2 for short. Again, predates HIPAA by decades, but is lesser known. I often hear the question, why is there something separate from HIPAA? HIPAA is so comprehensive. Why do we still have a separate federal confidentiality law to apply when HIPAA is complicated enough? And just quickly, the intent of 42 CFR Part 2, when it was first implemented, was to give particularly strong privacy protections to people who are at risk for or are seeking or have received treatment for their drug and alcohol problems, to encourage those persons to seek treatment, remain in treatment without fear of stigma and repercussions that may occur if their family members, employers, or others would find out about their need for treatment or receipt of treatment. And the law has been looked at repeatedly recently as more and more efforts are made to bring it in line with HIPAA. I frankly don't see it going away completely. It might become more akin to HIPAA at some point, but I think it will still remain a separate law. Sorry, my slides are getting away from me. Okay, so in terms of who is required to comply with 42 CFR Part 2, and again, this is all going to be really important when we get into how the jails and the courts and the behavioral health providers can share information. So, you know, this is part of building that groundwork of applying those laws. Most all substance use disorder treatment programs are covered by Part 2. They're covered Part 2 programs. There's very few exceptions. I'm not even going to go into those exceptions at this point. And all of Ohio's certified substance use disorder treatment programs are required to comply with 42 CFR Part 2. Wanted to make everyone aware of this rather new category under 42 CFR Part 2. Again, very important to all of the professional disciplines that engage with these Part 2 programs. Just a year or two ago, they added a new category of those that are required to comply with the disclosure of Part 2 information, with those requirements. It's called a lawful holder of Part 2 information, and those are persons or organizations that receive Part 2 protected information from a Part 2 program. So say, for example, you are a a mental health provider who typically is only concerned about complying with HIPAA. You don't provide substance use disorder treatment services. So you look at HIPAA, not Part 2. If you receive substance use disorder treatment information from a Part 2 program, you become subject to the disclosure requirements under Part 2. You become a lawful holder of Part 2 information. Same if a jail receives that information, Children's Services receives that information, a hospital receives that information. They might not be a substance use disorder treatment program themselves, but that information continues to be protected when it leaves the hands of the Part 2 program. And it goes further down the line from that. Third tier of persons or organizations that receive Part 2 protected information from a lawful holder of Part 2 information. Essentially, they made it very clear in the federal regulations that Part 2 protected information continues to be protected on down the line. Again, is going to be important as we talk about sharing of that information here in a little bit. In terms of what information is Part 2 protected, it is information that is created or obtained by a Part 2 substance use disorder treatment program for the purpose of providing that treatment, making a diagnosis for treatment, or referring for treatment, and that identifies the person as a substance use disorder services recipient or as having a substance use disorder. So this last point is really important because whereas I just said HIPAA protects any information obtained by a covered program that identifies the person, Part 2 only protects information that would specifically identify that person as receiving substance use disorder services or as having a substance use problem. So with HIPAA, where everything that goes into the record of a person receiving healthcare services is protected health information, Part 2 is very specific to protecting the information that identifies the person as receiving those services. And the important part of that is you might be able to make a disclosure under HIPAA, and if you remove the SUD diagnosis or other information that identifies the person as an SUD services recipient, you can go ahead and make that disclosure under HIPAA, whereas Part 2 might not allow that disclosure of information. Might be a little confusing just hearing it as we move along like this, and we can't really have the back and forth Q&A about it, but I have really taken time to spell that concept out in the manual itself and give examples of the difference that makes. And one reason it's quite important, as we'll see here in a little bit, is Part 2 is much more protective in terms of there are very few disclosures that can be made without the written authorization of the person. So in instances where you can remove the Part 2 identifying information, the substance use disorder specific information, and go ahead and make the disclosure under HIPAA, it can be very helpful to know that that's the way the law applies. I also have a note at the bottom here that the information becomes protected at the point the person seeks, applies for, or inquires directly about services. And that can be important. Going to the second point in this slide, you can disclose that a person, a Part 2 program can disclose that a person was a no-show for an appointment if it was arranged by a third party and not the person seeking services themselves. As I just said in that last slide, as soon as the person calls to make an appointment, applies for services, inquires about services, that information becomes protected. So if you're doing some type of referral from one system to another, it's always beneficial to not instruct the person to go ahead and seek those services, because then, say for example, court system refers a person and the person arranges the appointment themselves and they are a no-show, the substance use disorder provider can't reply to the court whether or not that person showed or not. However, if that person has had no contact themselves with the program, the court can call and say, did so-and-so show up for their appointment? And you are able to say, no, they did not, or no, they never contacted us, or what have you, because they have never sought services directly from you. And again, I just have at the top of this slide saying it in the opposite way in terms of what's not protected. If the information does not identify a person as receiving addiction services or is having a substance use problem, even if it's pulled from their medical record or chart, it's not Part 2 protected. It'll still be HIPAA protected, but it's not Part 2 protected if it doesn't include that SUD specific information. I wanted to point this out, and one of our submitted questions relate to this in one way. So I'll bring, when we talk about the submitted questions, I'll bring it back around to this slide. But when Part 2 just underwent a couple revisions last year, they made it very clear that Part 2 protected information is prohibited from being used to initiate or substantiate criminal charges against a person or to conduct a criminal investigation of the person. So no matter how you obtain Part 2 protected information, whether it was permitted disclosure, or whether it's the authorization of the person, Part 2 is very clear that even on down the line, whoever receives that information can't use it in criminal proceedings or investigation of a person. The only two exceptions are when a crime is committed on the premises of a Part 2 program or against their staff. Of course, information looking into the crime that was committed may reveal substance use disorder related information about that person. And the other exception is pursuant to a very specific court order issued for this purpose. And we'll talk about here in a little bit the very specific requirements of Part 2 when it comes to a court order requiring the disclosure of Part 2 information. So that was kind of my high-level overview of HIPAA and 42 CFR Part 2 in terms of who is subject to it and what information is protected by each of them. I want to move on now to the disclosures that are permitted to be made under each of those laws. So the general rule is that if a person or an organization is covered by those laws, for example, if you're a HIPAA covered entity or you're a substance use disorder treatment program or somebody that has become a lawful holder of Part 2 information, you must obtain the written authorization of the person to disclose their information unless the applicable law or laws contains an exception that applies to the disclosure. So I wanted to talk about the permitted disclosures under each of the laws in the context of sharing between behavioral health and criminal justice systems. So keep in mind, both of those laws say if you want to disclose protected information, you have to get the person's written authorization, except under the circumstances we're about to talk about for each of those laws. In terms of HIPAA permitted disclosures, in general, HIPAA's got quite a laundry list of disclosures that can be made without the person's authorization. If you've received or read the privacy notices you get from your own health insurance plan, or when you go to the dentist's office or the eye doctor, it has a whole laundry list of this is how we can use information without your permission. What I have on this slide is just those from that list that pertain to disclosures to the criminal justice system by behavioral health providers. I'm going to talk about a few of these specifically on the next couple of slides. So I will just mention the ones that are rather straightforward and obvious. HIPAA provides an exception for making disclosures involving reports of child abuse or neglect or about victims of domestic violence. It has an exception for judicial and administrative proceedings, and it has an exception stating that disclosures of protected health information can be made in order to reduce or prevent a serious threat to public health and safety. So keep that one in mind, that if there is a serious threat to public health and safety, covered entities can disclose information, client-specific information, to those who are likely able to lessen or prevent that threat. Again, those are the ones I won't go into much detail about. I'm going to talk about a few of the more pertinent ones here on the next few slides. And these are all spelled out in the manual, including some of the details that pertain to each of them. Keep in mind, it always surprises me how this is still not as widely known as I would expect by now. I think we are, gosh, about 13, 14 years into the full effective date of HIPAA, and this still does not seem to be as clear as it really needs to be. HIPAA permits disclosures of protected health information for treatment purposes. So by a provider for its treatment activities or for the treatment activities of another healthcare provider, and that's the case even if the receiving healthcare provider is not a HIPAA-covered provider. We're going to talk about that here in a little bit. HIPAA specifically says whether you're a HIPAA-covered provider or a non-HIPAA-covered provider, that sharing of information for treatment purposes should always be wide open. And other covered entities, such as health plans, like our ADAM boards around the state, can share protected health information for a healthcare provider's treatment activities. So my example here is an ADAM board can disclose protected health information they have in their system to one of their contract providers for the purpose of coordinating treatment for that client between providers. HHS has really bent over backwards, and they have a lot of commentary and guidance on this, to state that the exchange of information between treatment providers or for treatment purposes was never meant to be impeded or obstructed by HIPAA. That piece is still intended to be wide open if the purpose of the disclosure falls within the definition of treatment that you have here on your screen. And as you'll see, it's not just limited to the provision of services, it's also coordination of services, consultation between healthcare providers, referral of a person from one provider to the other. I do recognize that some covered entities choose to internally have stricter policies about the sharing of information. That is something they are choosing to do internally, but HIPAA in and of itself allows this very wide open sharing to treatment providers for treatment purposes. So that's important to keep in mind. I'll sometimes hear, well, you know, such and such hospital or such and such provider won't share that information with us, even though we are also a HIPAA covered treatment provider. That is a result of what their internal policies state and not a result of what HIPAA states. So I always like to clarify that. As required by law is another purpose for which disclosures of protected health information can be made. I won't go into detail on it, but essentially what it's saying is if a law, federal, state, requires a use or disclosure of protected health information, it's okay under HIPAA. So HIPAA says if something else, including a court order, a statute, a regulation, requires disclosure of information, it's okay by HIPAA. One exception to that I'll just mention briefly, it's addressed in a lot more detail in the first manual, is subpoenas that are not a court-issued subpoena. Subpoenas that come from attorneys, for example, representing parties in court proceedings and legal proceedings, that is not considered a required by law disclosure. We're not going to get into that now, but like I said, the first manual in this series has a lot about those types of subpoenas, the non-court issued subpoenas, for lack of a better way of describing it. Let me give one example of that. I have an example. I think it helps hit it home a little bit. Ohio has a felony reporting law. So if a covered entity is aware that a felony has been committed by a patient or a client of theirs, because that law requires disclosure, HIPAA says that disclosure can go ahead and be made even though the information is protected by HIPAA. There's of course issues with certain professionals and privileged communication, but just in general, say for example, as a mental health organization, the entire entity is covered, so the information might not be part of a privileged communication. They can go ahead and report that they are aware a felony was committed by one of their clients because state law requires it, and therefore HIPAA permits it. Again, something else addressed in detail, of course, in the fourth manual are disclosures that are allowed to be made for law enforcement purposes. Again, since we have a whole nother manual that focuses on those, I just wanted you to see that in terms of their disclosures, there are quite a few purposes for which that information can be disclosed. 2 whole slides whereby a covered entity can disclose information to law enforcement. And keep in mind as we move through this section, this is specific to disclosures by HIPAA covered entities. I'll address disclosures by those Part 2 covered providers, the substance use disorder providers next. Very different story. So these are the purposes for which HIPAA permits disclosures to be made. This is going to be important as we get into the sharing of information with jails and behavioral health care providers. There is specifically a section of HIPAA that talks about disclosures to correctional institutions, which includes jails and other custodial situations. And in a nutshell, what you have listed in these bullet points is the purposes for which a HIPAA-covered entity can disclose information to a jail. So if the information is being disclosed in order for the jail to provide health care to the person, if the information is for the health and safety of others at the jail, inmates, corrections officers, jail employees, what have you, the disclosure can be made. For the health and safety of those responsible for transporting or transferring inmates, law enforcement on premises can be, information can be disclosed to them for the purposes in the law enforcement slide. And then there's this kind of squishy, undefined purpose for which information can be disclosed to a correctional institution, to a jail, and it's for the administration and maintenance of the correctional institution, of the facility. There's no definition of what administration and maintenance of the correctional institution, what that's referring to, but from what I've gleaned from HHS's commentary on that disclosure purpose, they're talking about if jail administrators, jail staff need to be informed of special accommodations an inmate might need, the need for recurring medication management appointments, factors in regards to their being placed in isolation or discipline needs. What's helpful here is that HIPAA does say that a HIPAA covered entity is permitted to rely on the jail or the correctional institution that the information they are requesting is for that stated purpose. So the HIPAA covered entity doesn't have to sit down and say, is the information this jail needs truly for the administration and maintenance of the correctional institution, and what does that mean? If the jail is saying, a jail administrator is saying, we need to know this information from you for our administrative purposes, the HIPAA covered entity can rely that it's going to be used for those purposes and make the disclosure accordingly. And if it's something that's not very clear cut, you might simply want to note in your records to document that you're relying on the representations of the facility that the information is needed for that purpose. As we wrap up as we wrap up HIPAA permitted disclosures, I wanted to talk about redisclosure of HIPAA protected information. There really is no prohibition. There's no explicit prohibition on the redisclosure of HIPAA protected information. So whereas I said in the beginning with the part 2, the substance use disorder information, it continues to be protected on down the line, HIPAA protected information, once it leaves a covered entity, there's no prohibition on redisclosing it. And that's because, as I said early on, the only persons and organizations that are required to comply with HIPAA are the healthcare providers, as I described in the beginning, and health plans. So if the recipient isn't also a HIPAA covered entity and they're not contractually bound to not redisclose the information, they can redisclose that information under HIPAA. Keep in mind, sometimes another confidentiality law might apply. So for example, as I said early on, Ohio's jails have their own set of confidentiality rules. So it could be that a HIPAA covered entity makes a disclosure to a staff at a jail that are not HIPAA covered, but the jail under their own confidentiality rule might be required to continue to protect that information. Aside from those exceptions, there is no prohibition on redisclosing HIPAA protected information once it leaves a HIPAA covered provider. And that's going to be helpful to understand when we talk about the sharing of information between systems and how to make that sharing work. Part 2, permitted disclosures. I notice we're after 1 o'clock now since we got started a little late. I'm going to go through some of these a little more quickly with a little less detail so we can get to the Q&A. Keep in mind, all of this is spelled out in the manual. I'm going over it all now just to kind of hit home some of the key points, lay the groundwork for understanding the confidentiality laws, and really when we get to the Q&A to be able to go back and look what we're basing our answers on in terms of whether disclosure is permitted or not. Oops, skipped ahead too far. Part 2, permitted disclosures in terms of those that can be made to the criminal justice system are pretty short and sweet. There are many permitted disclosures that can be made under Part 2 in general. Exceptions would be if a crime occurs on the premises of the Part 2 program or against their staff. They can make disclosures to law enforcement. In a medical emergency, they can make a disclosure to treating professionals that need that information to treat an imminent and serious medical emergency. Child abuse and neglect reporting, under all the confidentiality laws, those disclosures can be made to appropriate authorities. and then pursuant to a Part 2 compliant court order, which I'll talk about more here in a little bit. What's important to note with Part 2 permitted disclosures: there is no treatment purposes exception. There's no correctional institution or jail exception. There's no required by law exception. If the information identifies a person as a recipient of substance use disorder services, or somebody who has sought those services, very limited and very few disclosures can be made without the authorization of that person. That's why I was mentioning early on that Part 2 only protects that SUD specific information. So if for the purposes of your disclosure, you don't need to disclose SUD specific information, don't disclose it. Disclose what HIPAA permits to be disclosed, since it's a lot more of a practical list of disclosures under HIPAA. So even if Part 2 program has information in its records, if it's, say, for example, a Part 2 and a mental health provider, that they have both in-house, and it's not strictly a Part 2 protected or Part 2 provider, if they need to make a disclosure, say for purposes of complying with Ohio's felony reporting law, they might be able to make that disclosure under HIPAA and not be concerned about making a Part 2 permitted disclosure, because there is no substance use disorder treatment or diagnosis related information in that disclosure. Again, it's hard to convey that information right now, especially where we can't have back and forth discussion about it. It is spelled out in the manual. Last thing I'll say about Part 2 permitted disclosures or specific disclosures is that a court order is not a court order when it comes to 42 CFR Part 2. Over half of the Part 2 regulations talks about the specific requirements that courts must comply with if they are issuing a court order for the disclosure of Part 2 protected information. So often if a court needs Part 2 protected information and a Part 2 provider says, I can't disclose that information to you, it's protected by Part 2. If the court issues a order requiring disclosure, it has to comply with 42 CFR Part 2. That's news to a lot of courts, that 42 CFR Part 2 might have any applicability to them, but it does in terms of requiring disclosures of Part 2 information. Again, I won't go into what's on the screen here. I believe in the first manual, the law enforcement manual, I have a lot about court orders and what's required under 42 CFR Part 2. Last point on Part 2 specifically is, whereas I just said that under HIPAA, there's nothing really explicit in HIPAA prohibiting a redisclosure of that information once it's no longer in the hands of a covered entity. Just reiterating what I had said about Part 2, that information continues to be protected on down the line. So the only way redisclosure can be made of that information is with the person's authorization, or one of those very limited exceptions apply. You could also strip out the Part 2 identifying information, as I've been talking about as well. But that Part 2 information, it could go from a Part 2 provider to a board to a children's service organization, and it continues to be protected by Part 2, even though those are not Part 2 providers. Again, spelled out in the manual, so hopefully that's not too confusing at this point. Sharing information between systems. In this section, now that we've done the who does HIPAA and Part 2 apply to, what information does it apply to, and what disclosures can be made, I wanted to look at some of the specific requirements and some recommendations for sharing information between behavioral health providers in the courts and behavioral health providers and jails. So starting with jails, it's important when you're considering whether a disclosure can be made under HIPAA. I'm going to start with HIPAA, then we'll look at part 2. When you're looking at the information and disclosures that can be made between jails and mental health providers, the first thing to determine in figuring out what can be shared is if the jail itself is a HIPAA-covered entity. It's my understanding from asking questions around the state at my different trainings that in most cases, a jail is not a HIPAA-covered entity, but some are. The jail in and of itself would be a HIPAA-covered entity if they have healthcare on staff and they are transmitting those electronic transactions. As I said early on about HIPAA, being a healthcare provider doesn't in and of itself make you a HIPAA-covered entity. You have to be a healthcare provider that's also transmitting transactions electronically, whether it be for payment, authorization, claim submission, those types of transactions. If there is employed healthcare staff that submits claims for reimbursement or conducts other electronic transactions, the jail itself would be HIPAA covered. Because it's not practical for the entire jail to be HIPAA covered, the jail can and should set itself up as a hybrid entity. That's essentially where an organization that's subject to HIPAA says we have a HIPAA covered section of our organization and a non-HIPAA covered section, and really a jail would need to do that in order to carry out their main functions on the jail administration side. If the healthcare providers are external, are community-based, so say, for example, the jail contracts out their healthcare or community-based healthcare providers are coming into the jail, even if it's part of a contract being paid by, say, for example, a board or another source. If they are external to the jail is not HIPAA covered itself. The external provider is most likely HIPAA covered, but the jail is not HIPAA covered when it comes to those external or contracted out community-based providers. So it's important to note when you look at the exchange of information between jails and healthcare providers that they can exchange PHI with one another for treatment purposes. So say, for example, you do have in-house HIPAA covered providers, and you have external providers, community-based providers that need to exchange information with one another. They can exchange that information because it's for treatment purposes under HIPAA. I was looking ahead to see if my next slide discusses a different piece of this, and I don't think it does, so I'll mention it now. Keep in mind what I had said early on, that say, for example, a community-based HIPAA-covered provider wants to disclose information to healthcare providers of the jail. They're not HIPAA covered necessarily, but because they are a healthcare provider, the community-based provider can disclose PHI with that in-house provider. I had said that HIPAA made it very clear that the sharing of information for treatment purposes between healthcare providers should be wide open, and that's regardless of whether a provider is HIPAA covered or not. Disclosures by HIPAA-covered community providers, including those jail contracted providers to jail staff. If you think back to that correctional institution exception under HIPAA that I talked about, that's when those disclosures would apply. So say you have a community-based mental health provider that would like to or is being requested to share information to a jail administrator, they can go ahead and disclose information if it's for the provision of health care to the inmate, such as, medication related information. If it's necessary for the health and safety of the inmate, the example I gave is, if the person's suicidal, the jail would need to know that. Or if there's a danger to the health or safety of others, some threat of harm was made. And then we have that category I talked about for the administration and maintenance of the facility, and I gave my examples of some things that would fall under that category. And then this is what I had been looking for on my last slide. Information can be made to those jail healthcare providers for treatment purposes, even if the jail healthcare based providers are not HIPAA covered themselves. And then with authorization is the other way that information can be shared by that community-based provider to those in the jail. This next slide is something important to keep in mind. I had talked about HIPAA not continuing to be protected once it leaves the hands of a covered entity. So say, for example, under this previous slide, a community-based provider, mental health provider, physical provider, what have you, makes a disclosure to a jail administrator, such as about medications, so that the jail can provide health care to the inmates. That jail administrator is not subject to HIPAA. They can redisclose that information that they obtained from that HIPAA-covered provider. And you'll see examples of this throughout the FAQs, and the example I have here on the slide is the jail-based provider can notify the court of persons that were booked that have a history of mental illness or on psych meds, so the court can determine if diversion, early resolution of cases is possible. So whereas the community mental health provider themselves cannot, without the person's authorization, share that information to the court, our correctional institution exception allows that provider to share it with the jail administrator, and the jail administrator is no longer required under HIPAA to protect that information. They can go ahead and share that information with the court. So in talking about how jails and courts and providers can work together to share necessary information, you sometimes have to consider that flow of information and how these laws may facilitate or prohibit a certain flow, and you have to redirect to get the information to the persons that need it. Lastly, with jails and HIPAA, I will just mention that there are confidentiality rules that are specific to the jail workforce. It's rather similar to what HIPAA says in terms of that information can be disclosed to non-health staff at the jail for health and safety reasons, and that health records are confidential and only accessible by designated personnel. All of those rules are in the appendix of the manual. Part 2, disclosures to jails. There again is no correctional institution exception. There's no treatment purposes exception. So when a, say, community mental health or a community substance use disorder Part 2 program needs to make a disclosure to a jail that would disclose Part 2 protected information, they need the person's authorization to do so. The only other way to do it is one of those very specific Part 2 compliant court orders, or if there is a medical emergency and medical personnel at the jail need that information in order to treat that threat to health that requires immediate medical intervention. So in those instances, if a Part 2 provider needs to, wants to, is being requested to disclose information to a jail, the best approach would be to educate their client that it is in their best interest to disclose certain information, so that information about pretrial services, or when it gets to the court, specialized dockets or bail decisions, all of those things can be in consideration of their substance use disorder and needed treatment and medications and things of that nature. Moving on to courts and disclosures by HIPAA-covered providers to courts. There isn't a specific disclosure as we have with correctional institutions under HIPAA. So HIPAA-covered providers can disclose mental health information to prosecutors, defenders, court, a parole board, etc., with the authorization of the person, pursuant to a court order, and because it's HIPAA, just means a regular old court order, pursuant to a subpoena or summons issued by the court. If there is a threat to health or safety and information needs to be disclosed. And noting here at the bottom that court journal entries and court docket entries are not protected, even if the information originally came from protected health information and made its way to those court docket entries and court journal entries, that information can go ahead and be disclosed. But again, there's no overarching court exception like there is for correctional facilities. There's also no exception for mental health courts or court-ordered treatment. Disclosures to the court have to be made with the client's authorization or a court order, but frankly, in those situations, the courts have that hook where they can require authorization as condition of participation. Court can also say, for example, going ahead in my notes here. So the court can require authorization as condition of participation, and also a note here on the bottom that, say for example, authorization form permits a HIPAA-covered entity to share information with a probation officer for the purposes of that probation officer, needing to ensure compliance with treatment or other conditions of probation. That probation officer can disclose information to the court. Again, they're not a HIPAA-covered entity, and redisclosures of HIPAA-covered information are not protected. I put a note in here about forensic monitoring. Boards are required to engage in forensic monitoring or have a designated provider that does so. Because state law requires forensic monitoring and notifications under the forensic monitoring system, that's required by law disclosure, and it can be made under HIPAA. When it comes to courts and court proceedings under 42 CFR Part 2, again, because disclosures are so limited under 42 CFR Part 2, if a substance use disorder program needs to make a disclosure to a court, they need the person's authorization. There has to be that specific Part 2 compliant court order, not just the general court order, and programs should ensure that local courts are aware of those requirements. Or they could share information from court journal entries and court docket entries, essentially referring back to other information that's not protected instead of making a disclosure from their records. When it comes to drug courts and court-ordered SUD treatment, so when it's about a person's participation in a program that's a condition of their community control or their parole, or it's a post-release control sanction or something of that nature. Again, there is no exception per se under Part 2. It's got to be the person's authorization or that specific court order. But we do have an OMA statute that requires essentially the person to consent to disclosure for those purposes as a condition of their participation in SUD treatment programs. And frankly, as I said before, the court should require authorization as condition of participation. I am going to skip over this next slide for now because it relates to a submitted question that we received. So I've put together more detail than is on this slide. I'm going to briefly mention some of these general recommendations and considerations so we can get to our Q&A. Keep in mind that although there might be circumstances where HIPAA or 42 CFR Part 2 does not provide for, does not permit disclosure of information, a mental health or an addiction provider can always share general information about how to best handle an interaction with someone experiencing a mental health or substance use disorder related issue with the court or the jail or law enforcement. So if they're not looking for specifics about the person and the person's treatment and the person's diagnosis, if they're just looking in general how to engage in crisis intervention, how to de-escalate a situation, they can always consult with a mental health and addiction provider about, in general, without getting into specific disclosures about the person, how to better address, handle, interact with someone that is in the custody of the jail or is at the court or involved in court proceedings. Again, keep in mind what I said about non-HIPAA covered persons can generally redisclose information they obtain from a HIPAA covered entity. So you should look at the flow of your necessary disclosures. Like I said before, community-based providers really don't have an exception to disclose directly to a court protected health information, but they can make many disclosures to a jail for the health and safety of the person, and a jail is generally not prohibited from making disclosures to the court. So be thoughtful about your routine disclosure needs and about how you can locally make those disclosures work when you collaborate with the other systems. Keep in mind that the person's written authorization to disclose information can be obtained by anyone. It doesn't have to be obtained by the mental health or the substance use disorder provider. Court staff, jail staff, law enforcement, anybody, a family member can take an authorization form and present it to the person and hopefully educate the person about the need for the disclosure of the information, how it may be beneficial to them, and get a signed authorization form. Keep in mind you can use a multi-party authorization form that lists all the parties that need to exchange information. Authorization forms have specific requirements to be included on them, but as long as you're drafting your forms or using forms that comply with all of those requirements, you can have a multi-party authorization form that permits the ongoing exchange of information between the listed parties. Ohio, hopefully you all know, now has a standard authorization form in law that provides for the sharing of information between two parties. It's not a multi-party form, but it's sharing of information between two parties. And the thing about using the state form is that as long as it's properly and fully completed, the party that will be disclosing the information must disclose that information under state law. And they're also provided immunity under state law for making the disclosure of that information. The manual goes into quite a bit of detail about that form and the ODM and Neomed and other state sources have a lot of information about using it as well, but know that's a tool that's available to you. And then again, a judge can always condition participation in a court-related treatment program or specialized docket program or what have you on the signing of an authorization form by the person so that the court can get the information they need. So in terms of, that was my very quick overview of a lot of different topics, but again, want to give you, as you go through the manual and you go through the scenarios, that common and base level understanding of these laws to which you'll build upon, because when you get a disclosure related question, when you say as a mental health provider need to make a disclosure of information or asked to make a disclosure of information, you want to walk through the different steps in terms of, is this protected health information? Am I required to comply with HIPAA? Is this a permissible disclosure under HIPAA? You want to be able to walk through each of those steps that I just went over to get to the bottom line answer of whether you can make the disclosure or not. So I am going to talk about the 3 questions that were submitted earlier today, and then we can see what questions have come in throughout the course of the presentation. The first question I received was the one slide I mentioned that I was going to skip over because I have more at the end. It is about disclosures to those in the criminal justice system about persons whose information is protected by 42 CFR Part 2. So 42 CFR Part 2 states that there are essentially special rules for authorizations when a court needs to receive information about a person that is under the jurisdiction of the court. So the question specifically is, there has been some confusion in my county with the revocation of authorization language between one section of 42 CFR Part 2, which states that the authorization form has to say it's subject to revocation at any time, and another section of 42 CFR Part 2, which states that the authorization form must contain language saying it's only revocable upon certain conditions. What this is referring to is a section of 42 Part 2 that has special rules for disclosures about a person in a substance use disorder treatment program to the court when that person's treatment is mandatory or conditional as part of the criminal proceeding. So when it's about the disposition of the case or conditional release or parole or what have you. And the answer to the question is those special rules are in lieu of the general rule. Under both HIPAA and Part 2, the general rule is that a person who signs a written authorization for the disclosure of their protected information can revoke that authorization at any time. No conditions upon that, except in this very specific circumstance when that treatment is a condition of the person's early release, disposition of their criminal proceedings, condition of parole, then the form must be altered a bit. And it has to say that it is only revocable upon final disposition of the conditional release or other action for which the consent was obtained. So a couple other things that must be stated on the form. The disclosure must only be made to those in the criminal justice system who have a need for the information to monitor the person's progress under that court-ordered or court program treatment that the person is receiving. There's specific requirements for the duration of the consent. It does, in those very limited circumstances, permit those within the criminal justice system to redisclose information to others in the criminal justice system. And it limits revocation of consent. And in the back of the manual, I have in the appendix where it says authorization forms overview, there is a note that says important info to criminal justice system about the standard authorization form. This is exactly what that is referring to. It's stating that in those very specific circumstances, there are different requirements for the authorization form that apply and that must be utilized. The second question that I received says, please discuss the application of the rules on medical staff employed directly by the sheriff versus contract medical staff working at the jail. What if the contract medical staff person is making recommendations for mental health court or drug court as part of their evaluation of persons booked into the jail? So essentially what they're saying is, what's the difference between, hopefully this is, I'm capturing correctly what they're asking, if you have medical staff employed by the sheriff's office and you have jail contracted external community-based staff, what information can be shared between those two, and what if the external contracted staff is making recommendations for a specialized docket? So a couple things here. The jail contracted or external medical staff, HIPAA most likely applies to them. So I'm going to proceed with, in that case, HIPAA would apply as it does to most community providers. After determining whether HIPAA applies or not, your next question would be, is the evaluation they're conducting in order to make recommendations for specialized dockets, is that a general evaluation or is that an assessment? And the manual goes into that quite a bit. A general evaluation, as I use that term and as I explain that term in the manual, is not being conducted for the provision of health care. It might be conducted by a healthcare professional, but a general booking screen or a general evaluation, if it's not being used for the provision of healthcare, HIPAA would not protect that information. But if an assessment is being conducted that will be used for the provision of health care to that person by a healthcare provider, then that information is going to be HIPAA protected. If it's just a general booking screen, if it's an evaluation and it's not for the provision of health care and it's not intended to be used for the provision of health care, that general booking screen can be shared freely with the courts, with jail employees, et cetera. If, however, it is a health care related assessment where it is going to be used for the provision of health care to the person, it is HIPAA covered, and it can only be disclosed, for example, to other treatment providers or pursuant to one of the correctional institution exceptions, and only to the court with the authorization of the person. As I mentioned early on, if jail staff receives it under one of the permitted disclosures, they can redisclose it to the court. But what the distinction comes down to in terms of a HIPAA covered entity is in making that disclosure is this just a general booking screen to determine needs, specialized dockets, what have you, or is this a healthcare assessment that's going to be utilized for the provision of healthcare? And the manual does go into some details around that in terms of if there are dual purposes for the screen, then you have to err on the side of protecting it under HIPAA, or once a general booking screen is used by and considered by a healthcare professional for the purposes of the provision of healthcare, it would be as part of their records, HIPAA protected. So if you go to number 15 under the mental health FAQs in the manual, you'll see it addressed there, and it's also addressed in the jail specific section in terms of if you do have a HIPAA external covered entity that wants to disclose information to the medical staff employed by that sheriff's office. Keep in mind, again, if it's for treatment related purposes, it doesn't matter if the sheriff's employed medical staff are HIPAA covered or not. It's treatment provider to treatment provider, and that disclosure can be made. And it can also be made if it fits into one of those health and safety and administration of the jail type disclosures that we discussed. And again, you know, it's hard to know if I'm fully answering your question because these were just submitted and we can't talk back and forth about it, but I did notice that out of these last two submitted questions, they are addressed in the manual. So hopefully if that wasn't clear enough, you can go back and get additional information in the manual. The third submitted question that I had is about defense concerns. It says typically defense attorneys will immediately advise clients not to talk to others outside of defense staff or to sign releases only to defense counsel, especially at those initial stages of a criminal case, because in the course of the assessment, incriminating statements may be made. The person asking the question went on to say, we want to encourage our clients to be honest and forthcoming with mental health professional, but initial stages of prosecution, those disclosures can often work against them in the pending case if disclosures are shared with the prosecution and the court. So how is this issue addressed and protection afforded these defendants in diversion programs or intercept models you work with? So this was an interesting question for me because typically the questions I receive are, we want to share the information. How can we share the information? Are we allowed to share the information? Not on the flip side of how can we limit the disclosure of this information? But I did make a note to myself to address this in the third manual because I think it is a very important question and frankly just one that wasn't on my radar. So a couple things about it. Keep in mind when it comes, let's start with 42 CFR Part 2 and substance use disorder related disclosures. I had a slide early on in the presentation that says Part 2 information is prohibited from being used to initiate or substantiate a criminal charge against a person or to conduct a criminal investigation of a person. That is something your court should be made aware of when you're collaborating amongst the systems and figuring out how to make all of this work. It's very clear under federal law. They spelled it out in more detail than they have had in there over the last few decades. And said the information can't be used for that purpose except in very specific circumstances subject to a court order. It's got to be a very violent crime and things of that, and the information can't be obtained elsewhere. So in general, when, say, for example, a substance use disorder program is assessing a person for substance use disorder needs, or they're providing treatment to the person for their substance use disorder needs. Even if that information would get to the court, it is prohibited under federal law from being used as part of the prosecution of that person. And in general, say for example, for HIPAA, both of these laws limit the information that can be disclosed. So I told you that under HIPAA, certain disclosures can be made to the jail. So I've talked a lot about a HIPAA covered provider can share with a jail when information is needed for the health or safety of the person or for others or for the administration of the facility. There's a minimum necessary requirement to that. In general, information that is disclosed for those purposes aren't going to include incriminating statements. It's not going to be the entire assessment. It's not like, and if that's what is happening, it shouldn't be. If information is needed by the court or by the jail, it should be for those specific purposes for which they're requesting it. And it shouldn't be, here is the person's assessment. They signed an authorization so we could hand over the, the psychotherapy notes, the assessment of the person. It is just for, say, example, specialized docket consideration or diversion or pretrial services, and that level of incriminating information or the entire assessment or what have you shouldn't be needed or being turned over for those purposes. So, especially based on what this question states, you want to encourage clients to be open with their treating professionals. And in order for that to happen, they need to be reassured, if they have to sign an authorization for that disclosure, that it's only high-level info needed for those specific purposes, that the jail or the court will be receiving that information. And again, when it's not pursuant to their authorization, there is the minimum necessary rule, which is actually under both laws, saying that you can't just hand over an entire medical record or assessment for these purposes that we're talking about here today. So again, this was a new one to me, and it came in right before the presentation, but I will address that more in the third manual. And just keep in mind for now, if that's actually occurring in practice where the permitted disclosures to correctional institutions or the person's authorization is being seen as a wide open door for sharing anything and everything about these clients, that's not the intent of the confidentiality laws either. And I'll make a note to talk more about limiting to the purpose of the disclosure in the next manual. So those were the only three submitted questions ahead of time, and I'm guessing that Ruth or Haley have received some questions while I was talking. I don't have my chat box up, and I think that one of them is going to read the submitted questions to me with the time that we have left.
Yes. Hi, Christina. This is Ruth. And I realize we've only got about 12 minutes and we do have several questions. So the answers may need to be brief, or we may need to do some other follow-up. The first one, though, I think is pretty quick. It's just a clarification. Someone wants to make sure they understood correctly that related to medical staff and the jail, if the medical staff work on site at the jail but are a contracted company, this means they would likely be HIPAA covered, but the jail would not be. Is that correct?
That is correct, yes. And I do address that in the manual. I can't find the page for you quickly, but in all likelihood, those contracted community-based providers, even if they are working in the jail or on contract for the jail, they are probably HIPAA covered, but that does not make the jail HIPAA covered.
Great, thank you. The second question is a little bit longer. This person oversees a lockdown drug education program, which is run by the courts and probation department. All of our clients are on probation supervision and must be in the county jail prior to transport to our program. Is there anything that needs to be done for the county jail to provide our agency with medical, substance use disorder, mental health, or other information that would be useful in the supervision of these clients in our program in order to provide continuity of care. And then there's a second part to this question, which is, are all of the inmates and clients required to sign a 42 CFR Part 2 with the county jail and or with our agency?
So it sounds like in the first one, they are asking about what information the treatment program can provide to the external treatment program, can provide to the court's lockdown program. Is that correct?
They're asking if there's anything that needs to be done in order just for the jail to provide the agency with the treatment information that would be useful in the supervision of those clients.
And by the agency, they're talking about a treatment agency?
They're talking about that lockdown
program.
Education program that's run by the courts and probation.
Yeah, keep in mind that the jail is most likely permitted to disclose information they need to the lockdown program. So if you are talking about jail administrators and the information they have about the person, or if you are talking about information that came from booking screens or, reports of that person while they were in the jail, things of that nature, most likely are not protected by HIPAA or 42 CFR Part 2 and can be disclosed to the lockdown program to help them facilitate the treatment that they're providing to the person. I would guess in most instances, that is the case, that nothing's prohibiting the jail. In terms of what would be most helpful to provide, I frankly can't answer what information would be most helpful, but I can say that I doubt there's anything that would prohibit general information about that inmate from being disclosed to the lockdown program to help facilitate their purposes. And you had a second part of that.
So I think the second part was kind of a specific example of that. Are all of the inmates or clients required to sign a 42 CFR Part 2 with the county jail and or with that agency?
Well, if the 42 CFR Part 2 agency is going to be disclosing information to the jail, going the opposite way as I was referring to it, then yes, the Part 2 specific form should be utilized. And keep in mind, in those instances, you would most likely be using, because this is a mandatory program, you would most likely be using those criminal justice specific provisions for the authorization form. So jail to Part 2 program, there's probably nothing specifically protected there, but Part 2 program back to the jail, yes, you would need the person's authorization to disclose that information. And because it is a conditional or mandatory program, you would use those criminal justice specific requirements on the authorization form. And again, if you go to the authorization form section in the appendix, it will spell those out.
Okay. The next question, is it okay to include a team of people, such as a drug court treatment team, on one release of information?
So 42 CFR Part 2, when it supposedly was looking at coming more in line with HIPAA, it actually made 42 CFR Part 2 stricter in some respects, and this was one of them. They are looking at changing this back again, and I think it might happen sooner rather than later because it's the least controversial. What Part 2 says right now for a release of information, and you'll see this in the instructions for the form, is if the recipient of the Part 2 protected information is not a treatment provider or a payer, the specific name of the recipient has to be listed. So if Part 2 specific information is going to a mental health treatment provider, because they're a provider, you can simply list the name of the provider organization. Same if the information is going to a payer, you can simply list the name of the board or the insurance company, for example. But if the recipient is not a provider of services to that person or a payer of their services, you can't use an organization's name. You have to use a contact person. And that's obviously very difficult. If you're getting an authorization to disclose to a court, for example, or for other entities where you might not always have the same specific person that the disclosure is being made to, my best way to address that while minimizing risk is to list the name of the specific person / the organization they are with. So if that specific person is not the recipient of a ongoing disclosure for whatever reason, they're on vacation, they're out on FMLA leave, they've left and the form hasn't been updated, you at least have the name of the entity listed along with that specific person's name, so you can make that disclosure to the entity with minimal risk until you can get that sorted. But because that can be so challenging, I do think that is something that is going to be removed from Part 2 before too long.
Okay, thank you. We have a couple more questions. Should you disclose information about the whereabouts of a client as a HIPAA-covered agency if the police are looking for a client without a warrant or court order?
Yes, so under HIPAA, and again, different for Part 2, but keeping it specific to HIPAA, you are permitted as a HIPAA-covered entity to disclose protected health information to law enforcement to assist them in locating a suspect, a fugitive, a missing person. That's spelled out a lot more in the first manual, but a couple things to keep in mind. You said without a warrant or something to that effect. A warrant or some other compelling document would require you to make the disclosure. Absent that compelling document, HIPAA just permits disclosures to be made. HIPAA never requires a disclosure to be made. So HIPAA is saying it's within your discretion to disclose that protected health information to police unless they have something requiring you to make the disclosure. Everything throughout HIPAA is, if you keep in mind the premises of HIPAA, it's saying this information is required to be protected, except you are permitted to disclose it in these situations. It is never requiring you to disclose. Another provision of federal law might make you disclose. Another provision of state law might require disclosure, like our felony reporting law, a document, an official document requiring disclosure from a court or from law enforcement might require you to disclose, but HIPAA only permits disclosures, never requires it. So from the way that question is phrased, it would be within the discretion of the HIPAA covered provider whether they're going to disclose that information to law enforcement or not.
Wonderful, thank you. And we have one more question in 1 minute, so I'm going to take the risk of us over because we still have over 130 folks logged in. So I think they're very interested in what you have to say. Before I read this final question, I'll point out, based on your last answer, that Haley did post in the chat box, for those that want to scroll back and find it, she posted both of the manuals, the law enforcement manual and the current manual being discussed, that you can download and snag before leaving this webinar. Those are also available on our website, and I believe she's going to follow up with everybody who registered to send them out again. So not to worry if you didn't grab them. The last question, and I think you have addressed this, but it's worded differently, so let's make sure. This person says, we are a dual agency. When clients go to jail, the jail requests the client's diagnosis and medication from us. Do we need a CFR 42 compliant release in order to release this information? Or can we use the jail's HIPAA compliant release? Most of the clients have substance use in their diagnosis.
Yeah, so whereas I'll make this as brief as possible, for HIPAA, you can make that disclosure to the jail because they need to know it for the treatment of the person, the health and safety, what have you. When it comes to the Part 2 protected information, which would include that diagnosis, if there's substance use disorder medication in what you're disclosing, a substance use disorder diagnosis, or anything else substance use disorder identifying, you do need to use the Part 2 disclosure form in order to disclose that information to the jail. If there is nothing substance use disorder specific, you can simply disclose it under the HIPAA exception permitting that disclosure. Wonderful.
I think that concludes the questions. We've got various comments and suggestions for the future, which we will capture out of this at a later date. But Christina, thank you very much for such a thorough presentation, and thanks to everybody who was part of this. I know we lost a few people at the 1 hour mark, but most folks stuck in and are just now beginning to log off. So excellent. Appreciate it. Any closing comments that need to be made?
Hopefully, I know there are probably still a lot of questions hanging out there and probably some confusion with the nature of the presentation, how I went through it. Go back to the manuals. Again, we tried to make them as user-friendly as possible and see if those manuals or the scenarios in the back, again, those scenarios come from the field, so there might just be something specific there that would answer your question. Thank you very much, everyone.
Thank you, Christina. Appreciate it. Everybody have a great afternoon, and we look forward to next time.
Take care.
Thanks.